Okay, welcome everyone to hearing number 26. This is our the same panel's second hearing for today. We're dealing with the special purpose zones, DPZ, KN or NOS and ports today. Just to briefly introduce the panel members, we have Commissioner Solomon, Reid, Willis, and I'm Commissioner Gary Ray to hear this case. We've got for the record, we've got tabled statements from Mr. Phil Hinden, Littleton Port Company, Ag Research, and Orion. And Orion. So we've got those statements to consider as part of this process, but we're only hearing presentations from two submitters today, those being Synlait Milk Limited and Fonterra Limited. And we're starting first off the rank with Synlait Milk. So welcome to the hearing, Mr. Chapman. We're in your hands. Thank you.
Can you hear us? Andrew, can you hear us?
Yeah, I can, thanks.
Good. Yeah, so as you'll see on my right, we've got Andrew Metherall, who's our traffic engineer that's going to be talking to you soon. And I've got Eve Denacor that's also filed a statement. I'll come back to that in a minute, and Nicola Rikers as well as our planner. I'll just start with Eve's evidence. Eve's evidence has been updated for this hearing, but the changes are very, very minor. I hope you've got the tracked version so that you can see where Eve has made changes. It's just the difference between something being filed in September and now we're almost in April. So a few updates there for you. Just from me, I have filed legal submissions with you as well. And because this is the overriding zone that affects what Synlait can do, I'm just going to take you through a few of the requirements for a special purpose zone. And for some of you, this might be a bit boring, you'll know it all, but just to recap, what's happening here is that with the introduction of national standards in 2019, there were some changes introduced to the RMA that you've got to consider when you're doing a plan review. It's mandatory that by section 58 of the RMA that you consider the national standards. And what those national standards do is that they, for all councils, try to shoehorn you in to not developing special purpose zones, but you're to sort of, as a first priority, go through and see whether one of the zones in the national standards is fit for purpose. And if it isn't, you then have to go through a three-stage sieving process, I'll call it a sieving process, whereby you get information to justify a special zone being introduced. To do that, you're assisted by a joint statement from Fonterra and Synlait of the 9th of May 2019, where those two submitters to this plan did a joint statement saying why they met the sieving criteria to be considered as a special purpose zone. How am I doing, Nicola? Does that sound so good so far? The three criteria that you've got to observe are that the special purpose zone must be significant to the district. That step, I think, is a relatively minor one because this plan has already indicated that dairy processing activities are of regional significance. So that in itself gets past step one. The second one is that it's impractical to be measured through another zone. And I think that everybody looking at the relevant zones has looked at, could it be managed through rural or could it be managed through industrial? And this site doesn't have any of the infrastructure that would normally be associated with an industrial zone. And as the letter justifies, the built structure of Synlait is way beyond expectations for a rural zone activity. So that gets past, in my view, step two. And the third step is that it's practical to be managed through a combination of spatial layers. And that again goes back to the issue that dairy processing really is probably, as you're aware, nationally is often managed by special purpose zones, be it in Southland and Waikato or in the Taranaki region, which are probably the three most prominent. And Synlait and Fonterra have again given justification as to why you can't manage it easily through spatial layers. So just to start, I say that you jump through all of the hoops to get to today where you can consider it as a special purpose zone. I've said it's mandatory for you to take account of the national policy directives, national standards, and simply because you are satisfy a special purpose zone doesn't entitle you to simply throw out all of the national standards. They're still before you, but having jumped through those three hoops, they are, in my submission, the priority issue for considering it as a special purpose zone. And there's probably not too much else that's relevant in terms of the national standards to this particular hearing. Where Synlait's appeared before various panels on a whole raft of issues that I would say probably are of much greater importance than what we're going to be discussing with you today. It's almost like this hearing is the wash-up hearing of the other issues that haven't been considered in a noise hearing, a lighting hearing, or earthworks, any of the others that I detail in my legal submissions. But what I wanted to say is the same reason that we're asking you to differentiate between general provisions on, for example, noise or lighting. That same rationale can be applied, I believe, in terms of why you should consider special provisions that are targeted to a dairy processing operation that's set apart from general provisions relating to noise or lighting. It's because we're dealing with firstly, a very large industry, one that operates 24/7 around the clock, one that can't stop and start easily because the rate of what Synlait processes is dependent on what comes in the door from farms, and you can't let that hang round for a long period. So I don't want to revisit all of those provisions relating to noise and lighting, but they do demand in my submission special provisions in this zone. Not going to go over those again. The only other thing that I really wanted to deal with is what your test is about various rules, objectives, and policies, because that's prescribed by a few cases, and I've cited one in my submission, which is the Rational Transport Society case. And I want to just say that you're not here to find the superior or the very, very best provisions. You've got to find provisions which are the most appropriate. And most appropriate's been defined as meaning suitable, without any gloss in terms of putting the word superior on what is suitable. And I think that all of the provisions so far, we've tried to put rules on a plate in front of the panels to show why the provisions are both practical and suitable to Synlait's operations. probably just lastly, you'll be well aware that there's been a lot of consultation by Synlait prior to the plan being notified as to what the requirements for their operation have been. We worked, I think, in a very cooperative series of meetings with Vicky Barker and others to try and scope those. They're generally coming over from the DPMA rules that are in the operative plan, but just with adaptations to set rules in place which are practical for operation going forward. And the greatest change that's happened in Synlait between that time and now is the full implementation of the rail siding at Synlait, which was not canvassed at that time and now is, and that's generated primarily the changes to the noise rules. So that's all I plan to say in opening. And I suggest, or though you may have a view, that the most likely order is Mr. Denicore first, in case you've got any questions of him, then Mr. Metherall, and then Ms. Rikers.
Just to see if we have any questions of you at this stage.
Yeah, it was going to be one last thing that I probably should talk about, just the essence of the traffic rule that Synlait is proposing. I find it best to look at attachment 1 of Mr. Metherall's evidence, and that's the new rule. So the way the new rule operates is from a traffic perspective, if traffic counts are lower than the 2 thresholds in the plan, Synlait can just go ahead and apply for a building permit for the new structure that is in conformity with all the other dairy processing rules. We pause when traffic numbers from both the State Highway 1 traffic numbers and the Synlait traffic numbers, that then if they go above the thresholds, we pause to address what effects might be arising as a result of going over those numbers. The 2 tests to be applied is one, and these are what I'll call crude on-off type switches. They're not particularly refined. The first one just talks about the state highway numbers. So when they climb above a count of 15,500 vehicles per day, measured at the closest NZTA site, and I think, Andrew, that's somewhere down further towards Dunsandel from the Synlait side. I think it's Sheets Road, is that right, Andrew?
Yeah, it's just near Sheets Road, which is only within a kilometre or 2 of the site. And
the second tier that needs to be complied with is the movements out of Synlait need to be below or above, when it requires further assessment, 220 vehicle movements. And really between Andrew and Nicola, they've developed how that 220 vehicle movements is counted. And you'll see that under Rule B, that it's not only what is coming out the gate right now, it's also about traffic numbers associated. That's something that is consented but not built. So there's an artificiality of the traffic counts, and that they've got to factor those additional numbers in to work out whether they're above or below the 220. Secondly, they've got to do the calculations during the busy part of Synlait's year, which is why you'll see traffic counts being done between the start of September and the second week of December. That coincides when the most milk is coming into Synlait. Done Monday to Thursday on 2-hour blocks on each of those days that the traffic engineers have formulated is the busiest time. those readings, when you take the highest hourly reading within those 2 hours between 4 and 6, you then aggregate them across 8 measurements, because one for each day, Monday to Thursday. And then you derive a figure as to whether it's above or below 220 at that point. If the figures are below 220 and the state highway figures are above 15,500, no further action needs to be taken. Synlait proceed direct to a building consent. And this is done for pretty obvious reasons, in that Synlait doesn't want to be responsible or the guardian for the state highway network. If the state highway network's exploding but Synlait isn't, we really don't want Synlait to see mandated to go and consult with NZTA about we want X, Y, and Z in terms of an intersection improvement. I think that's probably for obvious reasons. So, and then below that, you'll see that the effects can be taken into account in the latter part of that rule. What effects can be taken into account? And that does require consultation with both KiwiRail and NZTA at that point. So it's a practical rule, taking the timing of the year and the timing when Synlait vehicle movements are at their very highest. We did mull amongst us as a team how we would factor in the change to rail and the outgoing vehicle movements, which were not contemplated in this rule. We haven't changed the rule in any way because of that, but it's a factor that should be in the back of your mind, that Synlait is trying to take all practical steps itself to reduce its reliance on the state highway network as part of the special purpose zone. It's doing that because apart from this process, it's got health and safety requirements for everyone that works and visits the Synlait site. And I venture to suggest that those health and safety factors might be even more prominent than district plan measures as what Synlait might do in 20 years' time or whatever in relation to how it designs its access and egress. So that's enough from me by way of introduction.
So thanks for that. And we will come back to that suggested rule, and maybe with Ms. Rikers. I'll be interested to see the track change version where the council's rule has been tracked to see just what the differences are. I'll be interested to explore any scope issues that might arise, and also NZTA Waka Kotahi's role in this, because I believe they lodged a further submission, but they're not taking part in this hearing. So I'm interested to hear from either a legal or planning point of view whether the changes, how they fit within scope, and any involvement of NZTA. But I did have a legal question, I think, so I'll put that to you now and see if the panel have any other questions. Just in relation, Mr. Chapman, to your submissions regarding the special purpose zone, and you went through the triggers and or the tests that need to be applied, and what I was going to just check with you, that there doesn't appear to be any contradiction by any parties as to those zones being in existence, or that they've been minted, if you like. There's no one, as I understand it, opposing those zones. So are your legal submissions to the effect that we should give greater weight to the relief you're seeking than we would for other zones, or where do we take those submissions in terms of the relief you're seeking?
Greater weight? I'm just making sure that you can jump through the hoops more than anything more. But of course, in designing something that's appropriate, then I am saying you give greater weight to practical measures to make sure that the zone can operate.
Okay, so that's fine. I just want to draw that link between the importance of the zones and the relief that's being sought. Okay, I think I understand that. The only other question I was going to ask you was more of it may not be an issue, but just to get your perspective from a legal point of view on the role of a roading agency, so Waka Kotahi is responsible for roading upgrades and improving intersections. And as I understand it, the Sinlay site comes off a side road. So the intersection is a state highway intersection with a local road. And admittedly, the access into your site is not far away from the highway. But as a general principle, do you have any sort of view on whose responsibility it is to maintain a state highway local road intersection for growth that might occur down that side road? Is there sort of legal principles involved there?
Yes, I think very definitely. I have views on that. Waka Kotahi is entirely responsible for the state highway network. But I'm going to defer to Mr. Metherall on this point, because what's critical to your evaluation is where Waka Kotahi have already signalled that they're going to make upgrades, and this this section of the state highway is kind of like in purgatory at the moment. It's not destined for any upgrades at the moment. So I take from that the state highway, Waka Kotahi, regards it as functioning perfectly well, not only now, but into the future, because state highway network upgrades have got quite a long fuse to them. Andrew might be able to tell you exactly where the planned improvements to the state highway are and what the timeframes for that are, but I can't.
Well, probably the reason I said it may not be an issue is because we're here being faced with a draft condition, if you like, or a rule that requires an upgrade at a certain time, and it seems that the applicant is on board with that, but subject to some amendments to make it more clear and more relevant, etc., and less vague, if you like. So there may not be a dispute at all. I was just curious as to, and I think you've answered it, what their role is in it. Yeah.
I think, Nicola, you can correct me, but I think that just the genesis of the rule is that Sinlay originally proposed that it was dependent solely on its traffic counts. And then the council also introduced the second tier of it and the state highway network trigger point. And I don't think, and again, Andrew's the best person to answer that there's been any dispute about the 15,500. It's related to where there's a level of service change on the state highway.
There was a meeting with NZTA and council and NZTA.
Oh, sorry, just use the mic because it's being recorded.
So there was a meeting originally, and so NZTA and council came up with that.
Right. Yeah. So I think I won't take that any further, because I think what I understand is we're now focused on the words and the rule itself rather than the principle of who should do it and that sort of thing. You know, that's how I understand it. So we won't take that any further. I've got no other legal questions, but does any of the panel have questions on the legal aspects?
I didn't, but I now do. And it was just something you said about justifying the Sinlay site to come under a special purpose zone. You talked about it being because its activities are special. And I'm a bit confused, and I might have taken this out of context, but in your paragraph 10, the first thing you say is Sinlay is not an exceptional development.
Yeah. That's going down a different rabbit hole. One of the things that the national planning standards focus on is whether a precinct, a special precinct within a zone, might deal with the issues that is raised by a particular residential area or a particular industrial area. And in order to qualify for being a precinct within a zone, you've got to be exceptional. So I've simply pointed out in my legal submissions that I don't think for any reason Sinlay is exceptional. It's an activity that is carried out because of what happens in the rural environment around it. It's just not unusual that there would be milk processing. So that's why I say it's not exceptional. So if you,
So,
what's a good example?
so sorry, but to me, special and exceptional mean similar things.
Okay. No, I think in terms of the national standards, there's a different meaning given to a special purpose zone that's created and the establishment of a precinct. If we had, for example, Rocket Lab coming to Canterbury, that might be exceptional. It could, sort of happen all around the country, but it's chosen Selwyn to be the home for the second Rocket Lab venture. And that would then qualify for precinct type rules in a plan specific to Rocket Lab. I'm saying you can't do that in this particular case with Synlait because the activity itself is not in the nature of being exceptional. It's just what needs to occur when you have rural farms producing a whole lot of milk.
Yeah.
It's got to be processed somewhere.
I understand. I thought I might have been taking it out of context, and obviously I was.
Well, no, I can see where your question comes from. Yeah.
Thank you.
Actually, my question was in reference to the same paragraph, so thank you for covering that.
That's fine. So we have no further questions of you at this stage, Mr. Chapman, if you'd like to take your next witness. Thank you. Mr. Denicourt, we have your statement. Thank you for providing that with the track. Originally, I saw the track changes. I thought you might have sent me the wrong one, but you sent me the right one. So thank you for that. I'll just see if is there anything you wanted to highlight? We have heard from you for other hearings, and we've been out to see the site now. Some of the panel possibly already had been there, but we've all been there today to have a look at particularly the access in there. Is there anything that you wish to highlight in your evidence at this point? We're just happy to take questions.
No, just take my evidence as read, and I have nothing to add. Thank you.
Okay, we'll start with Andrew. Have you got any questions, Andrew?
Thank you for your evidence. Just one question. Paragraph 21, and the commissioning New Zealand's first large-scale electrode boiler. I guess I could have looked that up, but I'm just curious. What is an electrode boiler? I'm assuming you're not boiling electrodes in it.
No, it's an electric boiler. So instead of being powered by coal or biomass or fossil fuel, it is just like a kettle in the kitchen. It's a big element, a big electric element that's basically boil water without any emission.
Okay, thank you for clarifying. No questions.
Down to Raymond, have you got any questions?
No, thank you.
Cool.
No questions from me either. Thank you.
Just on the rail siding, is that's something you've got in your evidence about it has the potential to remove truck move? It's possibly in Mr. Metherall's evidence as well, but can you just tell us a little bit more about that and when it came into operation and how effective it's been?
The rail siding is already in operation. It was commissioned and started operating in May 2021, if I remember correctly. The potential to remove 16,000 heavy vehicle movement is basically containers. So we can now load containers directly on the rail siding. To get to 16,000, we're a bit delayed because of COVID. But we will get there, but probably take another year for the supply chain to get back on track and the container movement being more steady. Right now, we're relying on empty container to be brought to site as fast as possible. Sometimes we still have to truck them, use heavy vehicle instead of going through the rail siding. But in the future, it's supposed to be basically a closed loop and removing the heavy vehicle.
Very good. Thanks for that answer. I've got no further questions. So take the rest of the evidence as read. Thank you.
Thank you.
Sorry, I think is it my turn? The sound just dropped out there and for some reason.
It's just because I didn't have my microphone on, sorry. Over to you. And if you've got anything to add in terms of what Nicola said in relation to the degree of consultation about the rule, you could perhaps tell the commissioners if you've got anything to add on that.
Perhaps I'll just quickly take you through a few kind of key points in my evidence. So I've sort of structured it to give a bit of background as to the Synlait site and access and some of the traffic parameters that have sort of input into this rule that's been proposed as a replacement of what was in the operative district plan. So if I take you to figure 1 on page 4, it shows the state highway traffic volume. And so this is in an annual average daily traffic volume, and that's the measure that we're proposing in the rule. So that means it's the traffic count on State Highway 1. It's counted almost every day, and then it's averaged across the year. So you get this quite consistent sort of number. You don't get a lot of variation in it. And you can see there that over the sort of last 10 years or so, it was growing quite regularly at a reasonable rate, certainly faster than it was prior to about 2013. In the last year, that annual average has dropped, and that's simply because of COVID. There was certain weeks where there was very little traffic, so that averaging has dropped that back. But I think that's an anomaly. So I still have confidence that adopting an annual average daily traffic volume from the State Highway 1 would be an appropriate measure. At paragraph 17 in table 1, I've got a summary of site traffic generation, which is the other measure in the rule. It's grown when we first measured it in 2012. It was about 80 vehicles an hour in the PM peak, and then it jumped up to 175 vehicles in 2016, and that reflected both some of the manufacturing and processing growth, but also a large addition of staff out at site. So they'd built an administration building. And then in the last 5 years, we did a count at the end of last year, and that showed that the traffic count had grown very slightly. And interestingly, the directionality meant that the traffic that was exiting to State Highway 1 was no higher than it was 5 years ago. And that was largely because some of the staff movements had changed on site. So whereas all the administration staff were out at Dunsandel or at the factory site, a large proportion had moved into the central city. And some of the manufacturing that had expanded over that time as well, and warehousing meant that there was more of a night shift pattern. So you had people coming in rather than necessarily all leaving at that time of day. So in essence, I guess, whilst the state highway traffic volumes increased a lot, the Synlait site access in terms of its sort of volume entering the state highway network or exiting the site and entering the state highway and the PM peak hasn't changed particularly a lot. I've summarised the most recent road safety records because ultimately this rule that's proposed is more about road safety rather than traffic efficiency. Traffic from the Synlait site doesn't impact the efficiency of State Highway 1 at all. It's the intersection itself is left turn lane coming off State Highway 1, a right turn bay coming off State Highway 1, and an acceleration lane heading south. So traffic that's entering or exiting the state highway to access the site doesn't particularly impact the efficiency of State Highway 1. The only efficiency impact is really felt by those exiting the Synlait site themselves, where they might have to queue or just for a little bit to get onto the State Highway 1 safely. So the road safety records have shown that sort of over the last 5 years has been a small number of crashes there. They haven't resulted in serious injury, but they're obviously of concern still to Synlait, and they've, as Ewan mentioned about the health and safety aspects, we got quite involved with Synlait about 4 years ago, looking at their health and safety measures and consulting with NZTA around that. And at the time, NZTA were looking at some improvements that were readily achievable, but they haven't been implemented at this stage. So the rule that's been proposed later and set out in the evidence is, in my opinion, more around road safety and trying to set a threshold at which point the delays to vehicles could lead to some form of increased risk taking, which then has a potential increase in risk to safety. In the meantime, Waka Kotahi at my paragraph 24 is carrying out a Road to Zero safety campaign. It has been called other things in the recent past. Safe Network Alliance led into, I think, the Safety Improvement Project. And they've got funding in the next 3 years in their National Land Transport Program for improvements to Templeton to Selwyn River and from Rakaia to Ashburton. And so those two sections don't pass the Synlait site. So as Ewan mentioned, it hasn't necessarily been prioritised by them at this stage. But that's not to say that it, as they work on this large program of works across the State Highway network, they won't come back to this section of highway. I've provided background to the rule, which I think you can take as read, and I'll answer any questions around that. The Synlait submission sought to effectively, once an improvement was done, to have the rule removed. We've stepped away from that submission, but having considered it further, I thought that there is some merit in ensuring that any assessment matters for the rule consider the level of change that might have occurred to the intersection or the local road network since that threshold has been reached. So just gives a bit of context when we're considering the future resource consent. That would be a restricted discretionary status, that you can go back and say, well, there's been no change to that intersection, so therefore maybe a higher restriction is required, whereas perhaps there's been a major change and that will sort of change things totally. And so that sort of deals with that uncertainty that Waka Kotahi and the council were concerned about. And I think it achieves something similar to what Synlait was after, but obviously they have to go through the resource consent process still. So in essence, I think what's come out of the evidence that's being presented today is refinements to the rule. It's not a particular change to what's being proposed by the council in their notified plan. And part of that is as part of doing the traffic counts last year, we had a good think about how we were doing them and what was practical areas of ambiguity in terms of how we might apply that. So it's paragraph 47.1 of my evidence. I've suggested that instead of there being a specific reference to New Zealand Transport Agency's nearest telemetry count site, and telemetry means it's quite a specific method of measure. It's not necessarily to do with the fact that there's a count site there or not. I'm just changing that to the nearest count site. The nearest count site is a telemetry site, but over time these can change, and particularly as roads change, the count site might get, for example, might be resurfaced, and it might not go in exactly the same format as it was originally. So that just provides a bit of flexibility in that. So it's, in my opinion, that's quite a minor change, just looking at implementation of this rule. At 47.2, the current rule isn't, or sorry, the notified rule wasn't particularly clear as to what was or wasn't included in the 220 vehicle movements per hour. So the formulation of the rule was anticipated to be after development, that sort of 220 vehicle per hour threshold would be an after development volume. Whereas it could be read that you just go into a traffic count, and as long as it's less than 220 vehicles per hour, then you'd be right. So we've added in these extra elements, which in my opinion, whilst it makes it clearer, it's probably also a little bit more constraining for Synlait to make sure that they're considering any consented but unimplemented traffic generation, and also any forecast traffic generation. And that just helps in terms of when we're doing this transport assessment that's required to demonstrate these traffic volumes, there's a clear threshold that hopefully there's less ambiguity there. And at 47.3, we've suggested that the traffic generation forecast is defined as being between the site access and Start Highway 1. And so that's something that sort of our analysis leading into this rule focused on that location. There's only, as set out earlier in my evidence, there's only about 2 to 5% of traffic heads to the south on Heselton Road. I think it's at the 2% at the moment. So it's a very small part of the traffic generation that doesn't impact the Start Highway intersection, which is what this rule is about. And then at paragraph 48, set out that in a suggestion that there's this additional assessment matter, and that falls into the matters of assessment which are included in my attachment A. And so that's just adding the extra element there to reflect that over time this intersection may change, and it gives us a understanding of, if there's been a major improvement, well, obviously that might change the ability of the intersection to accommodate more traffic. If it's been something very minor, then it may not change things to the same degree. So I think just in terms of that comment about the consultation, so probably 3 or 4 years ago, we discussed it with Waka Kotahi in the lead up to it. We provided analysis, and the same with Synlait with Selwyn District Council's transport advisors, and the general format of this rule was agreed as appropriate. And as I say, that I think the point of contention was about whether there was a sunset clause or not, and Synlait proposed to sort of take a different approach to that in terms of applying an assessment matter. So I think that's my kind of summary. I'm happy to take questions.
Thank you for that, Mr. Medal. Just on that last point, consultation with council's traffic people and possibly Waka Kotahi, the rule that's presented to us now with some refinements, which on the face of it seem sensible, I've got to say, they seem to make things clearer. To what extent have you discussed those with council's traffic people, if at all, the actual wording and the implications of any changes?
We haven't.
That's fine, because it did occur to me late in the piece that we haven't got the council's traffic person directly involved in this hearing. And I was just going to ask you, Jessica, as a reporting officer, is the traffic person listening to this hearing right now? Is he or she going to look at the evidence that's been presented and be able to respond in some way as part of your reply? Is that what's intended?
They're not listening this minute because there's a bit of a question about how it will actually be, but this is being recorded, so we'll be able to show them the discussion, but it would be part of the writer reply. Their feedback on this would be incorporated.
All right, no, that's fine. It's just we understand there may not be a dispute about the rule itself. It's really just the mechanics and the parameters that have been introduced through here. But we'll we'll leave that for the moment. In terms of any other are you able to say why Synlait has sort of gone away from the sunset clause? I mean, what's presented to us is clear, but was there any particular reason for that?
I think that when we were proposing, or when the rule was developed 3 years ago, NZTA had a reasonably well developed intersection improvement scheme, but they also, and that looked at things like extending the acceleration lane to the south, widening the right turn bay, and improving the sort of safety design, I guess you'd call it, of the left turn lane into Heslington Road. But they also had at the same time a scheme which, as part of their safe network response, was potentially controlling movements to a greater degree, and forcing some traffic to turn left and then do a U-turn effectively. And so they're at quite an early stage. And whilst I've been applying those measures elsewhere through the Estate Highway Network, we hadn't kind of got to a point where that had been addressed any further here. So I think it was accepted that at the moment we can't be certain what sort of improvement.
Okay, and I know what's proposed here is more onerous than what you originally required, because it requires a consent process, or at least, and there's an assessment matter which you've gone through and explained. My final question related to the rail siding implications. We heard that it could reduce significantly the amount of trucks coming in and out, and the rule that's been presented to us has a or requirement. It's 15,500 vehicles on the highway. Sorry. And it's the average number of weekly vehicle movements at peak hours is not to exceed 220. So I guess what my question is would that delay, with the rail siding only being recently installed in the last year or so, would that extend the time when the 220 vehicles a day is reached out into the future by some years, or would it not have that effect at all?
I think what we've found from the traffic counts we've done over time is that the product-related heavy vehicle movements don't necessarily, well, they certainly don't peak in that same sort of peak period that the staff movement and some of the dairy tankers leaving the site occurs. So it's pretty much a 24-hour type operation. So you take that 16,000 and you divide it by the number of days of the year and divide it by 24 hours, and you get to quite a small number that kind of happens in a particular peak hour. That's not to diminish the overall benefit of having a rail siding from a land transport perspective, but in terms of the specific operation of this intersection, it's a component of it, but it's not necessarily a key part of it. So, for example, if there was 3 product trucks leaving in the peak hour, each of those might create a little bit of extra delay at the time that they're trying to access State Highway 1, but it doesn't particularly shift that overall level of delay significantly, because you've still got the other 200 or so vehicle movements associated with other vehicles that are trying to enter and exit at the same time.
Thanks for that. I think that's an important bit of evidence, actually, because without that evidence, the highway traffic could grow to, say, 20,000. And if you haven't reached your 220, you wouldn't be required to do any improvements, because the rail siding has dropped the figure down. But you've qualified that by saying it's related more to the peaks aren't quite so important for the truck movements in and out. It's spread over the 24 hours. I think that's what I took from your answer. Is that right?
Yeah, particularly related to that product movement. And and I totally agree with the earlier comment from you, and which I sort of mentioned again around the health and safety aspects of it. There's something that Synlait's, obviously thinks of it as one of the higher risks sort of matters for their site from a public or from their staff perspective, aside from obviously the on-site type of things. So they, have over time I've sort of observed how they've changed some of their patterns to manage traffic.
We're running out of time a little bit, but if you've got any questions on traffic, you can certainly ask one.
Just with regard to your paragraph 17, I'm looking at the table. And I'm not quite understanding 80%, sorry, directionality of traffic. I'm looking at that column, 80% out and 20% in. Can you please help? Does that have to do with the peak hour traffic?
Yes. So in the peak hour, we've got people leaving the site. So that's the out, and people entering the site. And so that's the in. So when we're talking about the performance of the intersection, it's primarily related to the people exiting the site, which is the out. So when you look, so I'm not sure, does that sort of clarify that?
No, well, I just see, but to my simple way of thinking, everybody that enters the site would leave the site. And so I'm wondering what the difference is between the 80 and 20%. All
right. So that's simply in the evening or the PM peak hour. So sort of typically say between 4:30 and 5:30 in the evening, you'd have 80% of that 79 vehicles per hour were exiting the site, and 20% of that 79 vehicles per hour were entering the site.
At that time?
Yeah.
Okay, got it.
And so over the day, yes, you'll probably have effectively a 50% in and a 50% out, but in a particular hour, more people are leaving in the PMP.
And at your paragraph 40, you say that it's fanciful to suggest there will be a marked change in traffic movement to and from State Highway 1 coming from the Sinlay site within the life of the proposed plan. Then in your paragraph 42, you talk about the longer term traffic needs of the Sinlay site. What do you mean by longer term needs?
So paragraph 40, that's in specific reference to the traffic that is heading south on Heslington Road. So Heslington Road's a gravel road south of the site. So it's the proportion that we're going down there. So I was saying that it was fanciful to consider that you'd have a large increase in traffic exiting or entering the site to the south.
Right, yes.
Paragraph 42. So what I'm saying there is that when an intersection improvement is developed, you don't necessarily just do it so that it will get you through the next year. Sometimes you might, because you might say, well, something's better than nothing, but usually you do an improvement that will help the intersection for 10 years or 15 years or 20 years. And so that's the longer term consideration.
And just lastly, do you think the low crash rate, or rather the low loss of life crash rate, has got something to do with why Transit or Waka Kotahi are not spending any money on your part of the road?
Certainly they, and my understanding is that they'll be targeting sections of road that have a high incidence or risk of serious and fatal crashes. And so part of that is based on just the type of road network, and part of it's on what's actually happened in that road network. And so at this location, I think that that's probably where they've got to. I mean, their prioritisation may have been based on previous years as well. So prior to when these crashes started to happen. So over time, they'll reevaluate those things. But my understanding would be that it's because it hasn't had at this particular location as many and fatal crashes as potentially other sections. But that's not to say that this section shouldn't necessarily be looked at closely.
No. Okay, that's all from me. Thank you.
I think Mr. Meadows stepped us through his evidence quite carefully. Thank you. Yes, thank you. It's very well compiled evidence. So we have no further questions of this witness at this point. Thank you.
I think pretty much everything's really been covered, apart from just confirming. So the rule at the moment, or the rule requirement, is if you don't comply with it, you become a restricted discretionary activity. There's no change proposed to that. And in terms of your question around what is the scope, I guess my evidence would be that none of the substantive matters that have been agreed between Council, Waka Kotahi and Sinlay have changed. It's more the matter of detail and actually setting that out with clarity now, which avoids, I guess, any confusion or arguments through a consent process. And I would suggest that these changes assist administration of the plan. They don't apply to any other sites in the district, and it's not actually liberalising anything. So
just on that,
Yeah.
I saw that in your evidence.
Yeah.
Is that linked to any section? Is that section 16.2, or is it
no, that's just
your own
me.
observation?
Yeah.
Yeah, that's fine. In fact, you've applied quite a rigorous analysis of it, probably more than the section 16 requires. So
Right.
your reasons are planning reasons, aren't they?
Yes.
Related to
yes.
scope. Okay.
Yeah.
Thank you.
That's it from me.
All right. No, thank you for that. As you note, a lot of it's been discussed already. I'll just see if the panel have any questions of your statement. Start with you.
No, thank you.
It's not really a question. It's just a note. I mean, I think at paragraph 21 you talk about suggested amendments and track changes, and I think that was covered at the outset. So obviously there's no track changes in the PDF version that I've got in front of me, and there's some track changes in the Word version of your evidence that was sent out, but they're not full track changes of the provisions either.
So I do apologise. So in my version that I'm looking at, there are track changes to the first clauses A and B, but when it gets to 1, 2, and 3, that's no longer clear. So I could resubmit that with improper track change in Word if that would help.
I think that would be helpful. So
Yeah.
the Word version I've got, there is some changes, and then it's just you've just got the new clauses shown without showing what's struck through in the Word version. And in your PDF version, there's nothing in my version that's track change at all.
Okay, I wasn't aware of that. So
I don't know if that's peculiar to me. Okay.
oh, okay.
Yeah, just send them through again, maybe just, to be clear, and through to Emma.
Sure.
Thank
and
you.
We'll get those. Yeah, thank you. You had another question, Jen?
No,
Oh,
no question.
So I'll just check my 12. All right, I think I've understand it. Now, I had a question in relation to paragraph 12, last sentence. I understand that regardless of this change in transport mode, Sinlay does not take any issue with the inclusion of the capacity-based rule. That's the capacity on the highway 22,000, 15,500. Is that right? Yeah. And just finally, when I asked Mr. Methera, I think you would have heard that question. I asked the way the rule's constructed, both A and B have to be met before roading improvements take place, and that requires both the traffic volume on the highway to be triggered and the volume through the access. But as far as you're concerned, you understand that the 220 is not a sort of a fanciful figure based on the rail siding reducing the traffic so that it'll never be reached. It's a realistic target because the projection shows it going up. The rail siding presumably will drop it a little bit, but you're satisfied that that's a reasonable rule in that sense?
Yeah, well, it combines the two volumes, and I mean, the Sinlay volume is based on modelling and traffic counts conducted, over a period of years now. So I would have some confidence in those numbers, and based on what was done originally in the plan change, and the traffic counts for the highway come from NZTA. So
yeah, I was more interested in the effect of the siding because I'm not sure that was modelled or part of the model. I should have asked Mr. Methera that question, but
I think you'd be better to ask him.
yeah, okay.
Yeah.
I can actually now, Mr. Methera, if that's okay. Was the impact of the siding in reducing, potentially reducing the growth of access traffic out through the main access part of the model, or was it factored in any way, shape or form?
I was just looking back at the start of my evidence as to where we, the year of that assessment, but so we gave advice to this rule after we'd done our assessments for the railway siding. So I think we had allowed for that, but ultimately the rule itself is about a measured volume. So it's not necessarily saying that it's to do with any particular activity on the site. It's saying that up to a certain level, there's a threshold before you have to seek a resource consent, and that's based more on the levels of service at the intersection. So it's sort of a little bit independent of exactly what's happening on the site, but we had taken that into account. We had a traffic volume that we had measured, but it was before the rail siding went in. We've now done a traffic count after the railway siding's gone in, and the traffic volumes are very slightly higher, but as I said, they're very similar. So there's probably about a 20%, 15 to 20% growth potential, I guess, on the side road to hit that 220 vehicles per hour. So that's sort of more related to opportunities for staff coming and going.
Okay, so sorry to harp on, but if I understand that answer right, you have taken account of the operation of the siding since it's been operating to arrive at that 22,000. Is it I just want to be assured that it's a reasonable figure and won't happen in, say, 10 years' time while the highway traffic has grown by more than 22,000. We end up with no ability to require a new intersection. Do you see my concern? And so really what I want is some assurance that the effect of the siding has been taken account of in the modelling. And if I'd be happy for you to send me or send us a separate note to that effect, or to explain the effect of the siding on those projections, so that we can take.
We might be able to clarify that now, because I believe Mr. Metherall's answer has clarified that for you.
And I took it to mean that it has been included. So if that's what you're submitting, that's fine.
I understand Mr. Metherall to say that he has taken that into account, but the rail siding doesn't really change the figure in any meaningful way, but it has been taken into account.
That's fine. We've been told that it's 16,000 trucks, which is a big number, and the evidence is that it's spread over 24 hours and so forth. So, and this is a peak hour rule, so that's yes. What I took from it. If I haven't understood that correctly, by all means, send in a note that that's what I've recorded. Okay.
Your understanding is correct. Yeah.
Thank you very much. And on that note,
just one further point from me, and it's a really minor one. I know that you said at the start of this hearing that Mr. Hinden has filed a submission. That submission, as I understand it, relates to a noise issue, primarily looking at the evidence of Gary Walton that was filed for Synlait and discussed in the context of the noise hearing. So I really want to say to you, in terms of this hearing, Mr. Hinden's submission is simply not a relevant submission relating to the special purpose zone.
Okay, I'll take that into advisement. I wasn't part of the noise hearing personally, but I think some of the other panel members were. We'll take your point on that and consider it. Thank you. All right, on that note, I don't think we have any further questions, and do thank you for the time and effort of putting your presentation together. And we'll thank you, and we'll take the next submitter, which is Fonterra. The Fonterra team available? Yes, we do. We have someone there. Oh, you're waiting. Yep. Okay. You've been there the whole time. Hello. Welcome to the Fonterra people. I see Ms. O'Rourke there and Ben W. Hello, Ben W. We're sorry, we're slightly delayed, but we're ready to take your submission now. Thank you.
Thank you. So I've sat through the Synlait presentation. So probably at the outset, I want to emphasise that both in terms of my legal submissions and Fonterra more generally, we've taken quite a different approach, which is to really regard the dairy processing zone as a matter not being up for debate, and we are really just looking at details now. That's not to say, and I certainly echo Mr. Chapman's comments, really the importance of the zone to both sites In Fonterra's case, we went through the Plan Change 50 process in 2017. I think that was made operative, with a lot of effort being put in that time to sort of get things right. So what we were really hoping in the plan review process, as much as anything, is that there was a rollover with tweaks, and our legal submissions and evidence have really pitched around that. So I'm not going to go through planning standards or anything like that. So, and as you would have seen from my legal submissions, they're really just focused on one point, which is the appropriateness of DPZ 3. To some extent, that becomes a little bit moot, as you would have seen in our evidence, as that issue's developed, with a proposal now to delete that and replace it with DPZ requirement 9. So really what we're trying to do is align the Fonterra site and approach with what's been put forward in relation to Synlay. I appreciate in terms of the last presentation, there was a lot of quite technical evidence on traffic and rail and things like that. I guess where the Fonterra site's a little bit different is by the time we got to Plan Change 50, Fonterra was effectively up and running, fully developed with a working rail siding. So there was sort of not quite the same issues or angst, re some of the traffic effects. And similarly, we're not also dealing with the interface between a state highway or State Highway 1 on the Synlay site and a local road. Obviously, the Fonterra site accesses onto State Highway 73, which you would have seen from the previous assessments is a lot more straightforward in terms of traffic effects. So again, really the intention was just to roll that over into this process as best we can. Just in terms of who we've got from Fonterra, Suzanne and Susanna. So Ms. O'Rourke has provided a written statement previously in relation to the noise hearing. She's National Policy Manager for Fonterra. She's here to answer a question. We've also got Ms. Susanna Tate. You should have a written statement from her and a summary which you would have received hopefully this afternoon. The summary touches on one additional point in particular, which is I understand Ms. Rikers has proposed some further amendments to DPZ MAT 3, focusing on the Synlay site. Obviously, to the extent that that applies to Fonterra, the similar amendment should also be made in relation to Fonterra's operations as well for that. But just really picking up on the last comments in relation to the Synlay presentation, I'm wondering if the best approach for the panel and us for that matter is for us to reach out to Ms. Rikers after this hearing and try and put together a consolidated set of provisions as between Fonterra and Synlay and provide that to the panel so we're not suffering with multiple versions and iterations from different submitters. So beyond that, I'm not proposing to cover my legal submissions at all. As I said, they are a little bit moot now given that we're the direction of travel, but I'm happy to take any questions on anything.
Okay, thanks, Mr. Williams, for that. Yeah, you may not have heard, the panel went out and had a look at the site, your site today as well.
Oh, thank you. So yeah,
yeah. So I think we've all driven past it, but probably haven't studied the sort of access arrangements and what have you. But it's quite a large scale intersection into there, isn't it? And with lanes, you know, very long approach lanes and departure lanes and so forth. It's slightly different to Synlay in that it's a direct access onto a lower trafficked road, but it's quite dedicated, isn't it?
Yeah, and as you can see from the assessments, there certainly was a sort of quite a significant exercise in future-proofing the site, so to speak, in terms of those past processes. So, you know, I've covered it already, but we don't have the same issues that Synlay's had over recent years with bringing in a new rail siding and things like that. So it's sort of, it is as much as anything a BAU situation for Fonterra.
Yes, okay. Now, I don't imagine there'll be any questions of the legal side of it at this stage. No? Oh, you do? Yes, sir.
From me, sorry. Just one from me. Your condition precedent. I note the case laws you provided were cases that occurred in 2004, 2011. I would presume that other hearings have relied on a condition precedent.
Yeah, look, I think we need to be careful. Sorry, yes, you're right. Sort of several concepts being thrown around in this process, reconditioned precedent versus the extent to which effects have been assessed as part of a plan change process or prior to a plan review process as we're dealing with here. So the conditioned precedent issue arises often in a resource consent context, is covered in all sorts of cases every day of the week, and really focusing on the extent to which certain things can happen outside a consenting process with a decision maker still being confident around grant, with the court generally putting forward the proposition that if something's granted in reliance on something else happening, that's generally okay, but it's not appropriate to delegate future decision making to a future decision making. Here we're really dealing with a slightly different proposition, which is covered by the cases I referred to in part, which is the extent to which a plan review panel, as we have here, can have confidence in plan provisions which anticipate certain things from occurring, and as is set out in the Fonterra evidence, at least in relation to traffic, which seems to be the live issue, there is a lot of confidence around that for the Fonterra site. So the general proposition I'm putting forward is we're not kicking the can down the road on an effects assessment here.
Okay, so you're not accepting the section 42A report that says it's ultra vires?
No, so what, as I said, it is a bit of a moot point, Commissioner, with regard to the slightly different approach that's now being taken, but we don't see it as a ultra vires issue here, given that the effects have been very comprehensively assessed, and we're obviously dealing with an existing site and intersection as well. So, yeah.
No, all good, thank you.
So that's it from me. So I was going to.
Sorry. We might have a question still coming. So
it was more just in relation to paragraph 11. So you're essentially saying that there appears to be one rule for Synlace and one rule for Fonterra, but actually, you're essentially trying to seek the same thing. Is that right?
That's right, but just acknowledging within the rule wording that the Synlay one will obviously naturally be a little bit more complicated for the issues you've talked about for the last hour, but we do want to be as consistent as best we can, and as much as anything, roll over the approach of the operative plan as best we can as well.
Yeah, and I'm assuming if the rule for Synlate is vires or is lawful, then the approach should also be the same for Fonterra then.
Yeah, depending upon if it's a point of detail or a more philosophical widespread proposition, but if it's a point of detail, there might be a difference between the two. If it's a wider position, they'll accept this. So that might naturally follow.
Okay, thank you. No further question.
Thank you. We'll take take your witness now. Thank you.
So I was going to pass over to Ms. Tate, who, as I said, has provided a summary to the hearings officer, but I'm not sure that's made it to you. So.
Oh yes, we were doing a site visit while it arrived, so we haven't actually read it. So if you would take us through it, that'd be appreciated. Thank you. Yep.
I'll leave in hands Ms. Tate. Thank you.
Good afternoon. There's really just, 3 points probably that I've touched on in my summary. All other points, I've supported Ms. Tuilepa's recommendations. So there were just 3 outstanding matters. The first one is in relation to Rule 2, and the definition of rural production has the potential to capture some dairy processing activities and facilities that would otherwise be permitted by Rule 1.1. So I've recommended an amendment to Rule 2 just to make it abundantly clear that nothing that would otherwise be permitted by Rule 1 is captured by Rule 2, and obviously the rule requirements, including the height and location of buildings, which has come through in the submission by the council, and which was recommended to be accepted by Ms. Tuilepa. So moving on to Rule 3, Rule 3. Ben's obviously covered off, I guess, the the approach that we're proposing. So like Sinlay, we would look to have a rule requirement, so have Rule 3 deleted in its entirety and have a new rule requirement. I confess there were some copy and paste errors in the version that I submitted in my original evidence. So in my summary, I've sought to correct those. So as part of the plan change, there was an approval of 170 vehicles in a 30-minute period. So that would be the threshold that we would look to have as a permitted threshold. We would prepare a traffic assessment would be prepared when any building or addition is to be added into the site that would increase capacity or storage. And rather than going to Wakakatahi, which is what is expected under the operative plan, that function would be brought back into council. I guess my take on the operative plan wording is that if there was a function, there was effectively a threshold that was approved and accepted, and the function of having that checked in light of any additions that may occur on site was farmed back to Wakatahi and Kiwi Rail. And I guess I'm now saying that that can be brought back into council as part of this rule requirement and in line with the approach that Sinlay have taken with requirement 8. It would default to, in the event that that threshold is exceeded, then it would default to a restricted discretionary activity, and the DPZ Mat1 matters of discretion would come into play. As Ben touched on, Sinlay have sought amendments to those, which make them very specific to their site. And in my summary, I have included some wording. I've tried to capture what Sinlay have requested, and but obviously backfill it to also accommodate Fonterra's requirements. And as Ben noted, we would appreciate the opportunity to workshop these with Sinlay and reach an agreed position to be submitted to the panel. And that is me, really. I'm happy to take questions.
Thank you. Just from me first, just in relation to that last point, I'm trying to get to grips with what's being suggested with a workshopping with Sinlay, because the rules are they not specific to each site, aren't they? One is for Sinlay and the one you're suggesting is for Fonterra. Why do they need to align, other than perhaps the assessment criteria?
That's the bit that I'm suggesting that we just the matters of discretion 1, I think they are.
Okay, and without having studied your assessment criteria, do you think they're not generally already in alignment? Or, I mean, I'm just trying to understand how much work might be required and why Sinlay would be motivated to take part in that exercise. I suppose they're asking us to include similar things, aren't they? Yeah.
Sinlay wrote, they revised, it was, you made note in when you were listening to Sinlay that the track changes didn't come through in their version. So in the absence of track changes, I've sort of made a comparison between what was notified in the plan and their wording. So it's more a case of their words were very specific to Sinlay and referred to Heslington Road and places that would just make that matter of discretion specific to them. I guess Fonterra is just acknowledging that to enable a full assessment, if their permitted activity threshold was exceeded, all of the matters of discretion should be considered, and which wouldn't be possible if some of them were specific to Sinlay.
All right, thank you for that. Yeah, I think I'll just throw it over to the panel for any questions. Again, Rowan. Yep.
Just one from me, and it's regard to the definition for rural production. And I'm looking at your paragraph 26, At what point of the processing does milk change into another product?
That question is probably not for me. Suzanne may be able to offer some insight into that question, if she'd like to answer now, or
Yes, please.
I'm not sure if I can give that a complete response without probably going back and having a further conversation with appropriate people at Fonterra. So sorry, your question was, at what point does milk change into?
So at what point of the processing does milk change into another product? Because in your paragraph 26, I'm sorry, in paragraph 26, it says removing water from milk doesn't necessarily turn it into a different product, which I presume is part of the rural production definition.
so if I may, so rural production enables an initial processing of a raw product, which is effectively what reverse osmosis is. I'm not the scientist. I don't want to tread on toes here and get it incorrect, but it's just a very quick process that removes some water from the raw product. And I understand that enables it to be more readily transported. So there's a reverse osmosis plant on the Fonterra site. On the basis of the rural production definition, the reverse osmosis plant could be considered rural production. It's only in subsequent processes that the milk, I guess, becomes the plethora of products that are produced.
Thank you for explaining what reverse osmosis is. Could you ask your scientists at what point of the processing does milk become a different product?
We can have a chat with the various Fonterra people and get back to the panel with the answer on that.
And just to capture that, Rowan, the reason you're asking that is as it relates to the definition of rural production. Is that right?
Yep.
Yes. In fact, it's clause D.
Yeah, I appreciate it's a part planning, part scientific question, so we can get back to the panel with something on that.
Yes, I think it might be both.
Thank you.
Yes.
Any questions, Nicole?
No.
Andrew, any questions?
Thank you, Mr. Chairman. Look, I did have a question in regards assessment matter 1, but I think you've covered that in your supplementary statement or summary statement that you sent through, so thank you. But I have one remaining question, and I'm not sure if it's an error or whether I'm just misunderstanding it. Paragraph 25, and you explore the overlap between rural DPZ R2 and I think in DPZ R1. And at the end of that paragraph, you then talk about rural production constrained by GRUS R2. Do you mean GRUS R2 or do you mean DPZ R2?
No, I mean the general rural zone, rule 2. So the council's submission on that rule was that the buildings were also added following rural production. So rural production activities and buildings, and then consequently because of that, GRUS R2 becomes a consideration, whereby the bulk and location effectively of those activities outlined in DPZ R2 have to also conform with the rural bulk and location requirements.
Okay, so I think there might be a change identified in section of footage report, so I'll go and have a look at that. Thank you. No further questions.
Thank you. I had a similar observation about DPZ R2 and the amendment to exclude activities covered by Rule 1.1. I'm interested to hear the reporting officer's comment on that. I didn't see it as being a problem, but I do understand your rationale and logic behind seeking that. But I'll be interested to know whether the reporting officer agrees there's a need to do that. So I'll just make a note of that, please, Jessica. And the only other question was to do with, it's been a long day. I can't recall exactly whether there's a scope issue with these amendments that are now being sought, including assessment matters and some other tweaks. Is Mr. Williams, you able to refresh my mind on the scope issue? Is it an issue at all in terms of the relief?
I'm not aware of any scope issues being raised in respect to the Fonterra position. I'm conscious that particularly if we're chatting with Ms. Rikers, there are some other tweaks which were thrown in the mix. I might take that offline and just double check everything and get back to the panel with a confirmed view on that. So.
Okay, I think what we'll do is after the hearing, the panel discuss whether we see a need for that conferencing or not. So yeah, we'll discuss that issue first and come back to you on that. Thank you. Now, just a final look through. It's covered. Okay, other questions? I think we're done. I think we're covered with that. So thank you very much for your presentation and attendance.
Thank you. Yeah, I've got nothing further to add. So, yeah.
Okay, we'll thank you for that. We'll adjourn the hearing. Thank you.
Great. Thank you.
Thank you.